Equality seems like a straightforward concept. Everyone is equal before the law. That's what the Indian Constitution says. But is it really so in practice? If everyone is truly equal before the law, then why do the rich pay more in taxes? Shouldn't a tax rate be exactly the same for everybody? Or take the case of a criminal law where a teenager and a 30-year-old can commit the same crime, but they end up in different legal systems with totally different punishments. So, where's the equality there? And then, of course, we can look at the concept of reservations. If the whole point is to create a society where everyone is equal, why on earth does our legal system have special provisions for certain groups? Either the Indian constitution is full of contradictions, or maybe our understanding of what equality actually means is incomplete. And the key to figuring this all out lies in understanding one of the most crucial articles of the Indian constitution, and that would be Article 14. Pay attention to the words used in this article. It's actually two separate concepts squeezed into one sentence. Article 14 says, "The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India." They sound kind of the same, but trust me, they're not. Let me break this down for you. First, you have equality before the law. This idea comes from English law, and it's what we call a negative concept. Now, negative doesn't mean bad. It means it tells a state what it can't do. It's basically saying the state cannot give anyone special privileges. Nobody is above the law. Not the rich, not the poor, not a government official. It's all about restriction. And then you have the part about equal protection of the laws. This is a positive concept that comes from the American Constitution. It tells a state what it must do. It says the state has a duty to make sure that people in similar situations are treated alike. This is the part that actually opens the door for things like affirmative action to help level an uneven playing field. And right here, this is where it gets really interesting, because this dual concept completely shatters the biggest myth we have about equality, the idea that equality means sameness. You know, we're taught from a young age that being fair means treating everyone exactly the same, but our constitution is way, way smarter than that. Imagine a 10-year-old kid and a 30-year-old person commit the exact same crime. Now, if equality meant sameness, you'd have to give them the exact same punishment. But does that feel fair to you? Of course not. It would be completely unfair, because you're ignoring massive differences in their age, maturity, and just basic understanding of the world. Treating people who are fundamentally unequal as if they are equal is actually a form of inequality. And that right there is a true genius of the Indian Constitution. Equality doesn't mean sameness. The real principle is you treat equals equally and you treat unequals differently. And suddenly, all those confusing questions we started with, they just start to make sense. Why do the rich pay more taxes? Because you're treating different income groups differently. Why a separate system for juveniles? Because you're treating different age groups differently. But this opens up a whole new can of worms, doesn't it? Actually, if you're saying the state can treat people differently, what stops it from going too far in the wrong direction? What's to prevent the government from just deciding, hey, we don't like this group of people, so we are going to treat them badly? Or we like this other group, so let's give them special perks. Well, this is where the Constitution puts its foot down. It puts a leash on the state's power. It says, sure, you can treat people differently, but you better have a really, really good reason to do so. And this control mechanism, this leash, is a legal test known as reasonable classification. This test is actually pretty straightforward. It just asks two common sense questions. First, is the difference you're using to group people clear and logical? This is called intelligible differentia. So, grouping people by age or income, that makes sense. Grouping them by, say, the color of the shirt they're wearing today, that's just random nonsense. And second, is there a logical connection between that group and the goal of the law? This is called rational nexus. So if your goal is to make public transport safer for women, then creating separate compartments for women makes sense. The group is rationally connected to the objective. If a law passes both of these tests, it's good to go. If it fails either one, it gets struck down as unconstitutional. This test was put into action pretty early on in a huge landmark case. The state of West Bengal versus Anwar Ali Sarkar in 1952. The West Bengal government created these special courts. Nothing wrong with that. But here's the catch: the government gave itself the power to just pick and choose which cases went to these courts, with no rhyme or reason, no clear rules, no guidelines. So you could have two people accused of the exact same crime, and one gets sent down a normal legal path while the other gets sent to a special court, all based on a government official's whim. Well, the Supreme Court took one look at this and said absolutely not. They said this isn't a reasonable classification. This is just pure, unadulterated arbitrariness. And I want you to remember that word, arbitrariness, because it is the key that unlocks the entire meaning of Article 14. See, over the years, the Supreme Court's whole perspective on this shifted. They had this realization that the real threat to equality isn't just making groups of people. I mean, the law has to do that to work properly, of course. But the real enemy, the true danger, is arbitrary power. You can really see this idea taking shape in the case of E.P. Royappa versus State of Tamil Nadu in 1974. This case wasn't about some law affecting thousands of people, it was about one government employee being transferred. His whole argument was that the government didn't transfer him for a good reason. They did it out of spite unfairly. In a word, their action was arbitrary. And it's in this case that Justice P.N. Bhagwati drops one of the most famous and powerful lines in all of Indian law. Equality and arbitrariness are sworn enemies. This was a game changer because suddenly the test wasn't just about whether a classification was reasonable anymore. Now, any action by the government could be challenged. If a government action is arbitrary, if it's done without a good reason, without fairness, then it's a direct attack on equality itself. And this powerful new idea was really hammered home just a few years later in another landmark case, Maneka Gandhi versus the Union of India in 1978. So the government took away Maneka Gandhi's passport, claiming it was in public interest, but then they refused to tell her why. The Supreme Court stepped in and said, hold on a minute, that's not how this works. You simply cannot take away a person's fundamental rights without following a procedure that is fair, just, and reasonable. And why is that so important? Because a procedure that isn't fair is arbitrary. And anything that's arbitrary is a violation of Article 14. Simple as that. So remember, Article 14 was never supposed to be about forcing an incomplete idea of sameness on everyone. Its purpose is so much bigger than that. It's a fundamental check on the power of the state. It's the mechanism, the tool that forces the government to use its incredible power with discipline, with logic, and with fairness. So the next time you hear that phrase, equality before the law, I want you to think beyond the simple idea of sameness. Understand it for what it truly is. It's a powerful promise, a guarantee that the state cannot act against you randomly or on a whim. It is your constitutional shield against arbitrary power.